This PowerPoint covers topics relating to civil procedure. This topic is very similar to the last topic we studied, which was the criminal pretrial procedures, but instead this time we're going to be looking at the civil pretrial procedures. You will need to know procedures such as pleadings, discovery, and directions hearings, as well as the purposes of each of these procedures. You will also need to know different types of civil remedies and their purposes, for example, damages and injunctions. In this topic, we are going to develop skills relating to description, comparison, and discussion. By the end of the topic, you should be able to describe the pretrial procedures for the resolution of civil disputes and be able to compare them and their relative purposes to the criminal pretrial procedures we looked at. You should also be able to discuss the ability of civil remedies to achieve their purposes. In this topic, we will start off with a quick introduction to civil law. Then we will look at how to commence a civil proceeding. Then we'll move on to examining 3 different civil pretrial procedures. These are pleadings, discovery, and directions hearings. Finally, we'll look at the types of remedies that you can get in a civil trial. These include damages and injunctions. Civil law governs disputes between 2 or more individuals, groups, companies, or government bodies. Often in a dispute, a person's rights have been infringed, and that person brings a civil action against the person who has infringed their rights. The aim of a civil action is to restore the party whose rights have been infringed back to the position they were in before the act or omission occurred. Usually, this takes place by giving the party a civil remedy. In other words, if you feel like you have been wronged, usually you will go to the courts and try and argue that the courts should force the other person to put you back into the same sort of position you were in before they wronged you. For example, the court might make that person pay you some money. There are a number of different types of civil disputes. Here is a diagram which shows a few of the more common ones. Defamation is when someone says something about you that might harm your reputation. Trespass can be either trespass on land, which you are usually more familiar with, or trespass to the person, which could be something like assault or battery. Breach of contract is when you get into a contract with someone and then break it. You could also bring a case relating to wills and inheritance if you have a dispute about the meaning of a will. Negligence is where someone owes a duty of care and acts irresponsibly towards someone. Nuisance is where you act in a way that disrupts the comfort or convenience of somebody's normal living. And finally, family law might relate to things like custody disputes or divorce settlements. There are 3 types of parties that could potentially be involved in a civil dispute. An individual might sue or be sued by someone. Alternatively, in Australia, corporations or companies are considered to be legal people. So a corporation could sue you or be sued using civil law. Finally, a government body such as the Victorian government or a local council or even a statutory authority such as the Victoria Police, they could be sued or they could sue you using civil law. Over the course of the next few slides, we're going to look at how you might start a civil proceeding. Taking a civil case to court is always a risk because there's always the chance that you could lose. So when deciding on whether or not to commence a civil proceeding, people will usually consider some or all of these following factors. How likely are you to succeed? Obviously, the higher the likelihood of success, the more likely you will be to want to start a civil proceeding. How much time and inconvenience is it going to take to progress your claim through the courts? This is the factor that usually prevents people from taking minor civil issues through the courts. If it's going to be too much time and inconvenience, a lot of people just won't bother. The other factor that people tend to consider and will tend to put people off is the cost involved. Hiring lawyers and gathering evidence tends to be pretty expensive. You also have to consider whether you have enough evidence to establish your claim. If your evidence is tenuous or weak, you might not bother going to court. On top of that, if you want to have a continuing relationship with the person that you're suing, you might consider avoiding court. because if you get involved in a legal battle, it tends to ruin relationships. Another factor to consider is how much money the other person has. If they don't have very much money and you win your case, there's a risk that they won't be able to pay you any compensation. And if that is the case, then there's often very little point in going to trial. And finally, another factor to consider is any potential positive or negative publicity involved with a court case. This is why frequently large corporations will try and settle a case before it reaches court, because being involved in a court trial will be negative publicity. When we consider each of these factors from the previous slide, we come to the conclusion that, for the most part, litigation is the last resort. If a civil dispute does arise, usually the wronged party will first try and contact the other party and try and resolve the matter personally. Usually, parties will try and avoid litigation until there are no other options left. Litigation will usually only be considered after other forms of dispute resolution, such as tribunals and mediation, have failed. Before you start a civil proceeding and formal court pretrial procedures commence, usually the plaintiff or their lawyer will send what's called a letter of demand to the defendant. The purpose of the letter of demand is to inform the defendant of the claim you're making and provide an outline of what sort of remedy you want. Usually the letters will demand that the defendant comply with the wishes of the plaintiff within a certain time limit and state that if you do not comply, the plaintiff is going to issue legal proceedings. If the defendant then fails to comply with this demand, the plaintiff can either choose to abandon their claim or proceed to a civil action. Alternatively, you can try and solve your issue with alternative dispute resolution methods such as mediation or conciliation. Here we have an example of what a letter of demand might look like. We see here that the defendant is called Mr. Chandler, and the plaintiff is going to be Mammoth Timber Propriety Limited. We can see the claim in the first two paragraphs, and they indicate that there was some invoicing for delivering of goods, which, despite several requests, were never paid for. In the third paragraph, we see the remedy that the plaintiff wants, which is a check for $35,000. They set a time limit of 7 days and state that if they fail to pay up, the plaintiff is going to issue legal proceedings. Or, in other words, they're going to take them to court. Once you've actually decided to take something to trial, there's a number of steps you have to take before you'll get there. These are known as civil pretrial procedures, and we're going to look at them in the next few slides. On this slide, we have a flowchart of all of the processes you might go through to try and resolve a civil dispute. The first thing we should notice is that on the left-hand side here, we have alternative dispute resolution methods that you might use to solve your problem. As we've already talked about, you would want to try and solve your problem through some of these dispute resolution methods before you went to trial. So for example, you might try and go to mediation to try and solve your problem rather than taking it to court. If that doesn't work, you might then send your letter of demand to the defendant. You'd tell them what you wanted, and you'd give them a time limit, and then if they didn't follow through with that, you might then step through the next few processes that would send you on your way to the court system. The first thing you would do is issue a writ. A writ is the most common method of commencing a proceeding in the Supreme Court. The writ will explain to the defendant that an action is being taken against them, and it will inform them of where that trial is going to take place. Normally, a statement of claim will also be included with the writ. This essentially tells the defendant what the case is going to be about. If the defendant wants to actually appear in the court and defend what they have done, they will have to file a notice of appearance. If they don't file the notice of appearance, they will get what is called default judgment, in which case the case is decided against them by default. If they do file a notice of appearance, the defense then gets the opportunity to provide a defense and a counterclaim. A defense sets out the defendant's response to each of the allegations contained in the statement of claim. So usually the defendant will go through the statement of claim and essentially write a document that says, yes, I admit point 1, no, I deny points 2, 3, 4, and 5, yes, I admit point 7, and so on. At this stage, the defendant can also make a counterclaim, which is when the defendant makes a claim against the plaintiff. For example, in a contractual dispute, the defendant might at this point say, "No, it was actually the plaintiff who broke the contract." At this point, discovery then occurs. Discovery is the stage of the pre-hearing in which parties exchange further details. They might exchange documents, something called interrogatories, and oral examination of witnesses. In other words, at this stage, the parties gather the evidence they're going to need at trial, and then they exchange that information with the other side. At this stage, parties will then both submit something called a certificate of readiness, indicating that they are ready to start the trial, and then the trial may begin. It's important to note that at any stage of these proceedings, a case might be abandoned or the parties might choose to settle it out of court. It's also important to note that at any of these points in the proceedings, the case can be referred by the court to alternative dispute resolution services. So they can be asked to go to arbitration, conciliation, or mediation, for example. I recommend, if at any stage throughout this PowerPoint you're confused about one of these procedures, you come back and you have a look at this diagram, and you have a listen to this slide again, and it might clear a few things up. This slide simply provides a different visual view of the pretrial procedures. If you prefer this view of it, you can view this at your leisure. The Supreme Court's civil pretrial procedures are set out in the Supreme Court Rules. This document sets out the details for every procedure we're going to learn about in this topic. If you ever want to clarify something or you want more detail, you can look up this document quite easily using Google. For our purposes, in this topic, you will only need to know the pretrial procedures of the Supreme Court. And in particular, we're going to focus on pleadings, discovery, and directions hearings. Although by learning this, you'll know most of the county court's pretrial procedures as well, as they're fairly similar. For each of these three pretrial procedures that we're going to look at, you will need to know what its purpose is, what it looks like, what its nature is, and the extent to which it achieves the elements of an effective legal system. This slide provides a list of all the things you're going to need to know for this topic. If you're the sort of person who likes checklists, you should return here frequently. So far, we have already covered letters of demand. The next step is going to be covering pleadings, including the writ, notice of appearance, statement of claim, defense, counterclaim, reply, and further and better particulars. Then we'll look at discovery and directions hearings. Over here on the right are a few procedures that you're not going to need to know about. Pleadings is the first civil pretrial procedure that we're going to look at. Pleadings are a series of documents that are exchanged between the parties. They set out what the claim is, they clarify what the defense of the parties are going to be, and they help to define what the legal issues are going to be. Pleadings are a pretrial procedure that include the following documents: a writ with statement of claim, a notice of appearance, a defense, a reply to a defense, a request for further and better particulars, and then finally the provision of further and better particulars. Each of these documents tends to get provided in a sequence, one after the other, each one being provided in response to the previous one being filed. This is an important stage because, in general, if claims and defences are not included in the parties' pleadings, they won't be able to make new claims or raise new defences later on in court, except with the permission of the court. The purpose of having pleadings is to require the parties to state what their main claims are and the defences of their case. This ensures that the other side knows what the case is going to be about, which makes the case fair and just. Pleadings also require that the parties have stated the material facts and particulars that they are relying on. This means that they won't take an opponent by surprise with facts that support their claim or defense. Once again, this helps to ensure that there is natural justice and procedural fairness. Pleadings also provide the court with a written record of the case. This helps the court to understand the issues and helps them better manage the trial and the pre-trial procedures. Pleadings set limits on the dispute, which enables other procedures such as discovery to be confined only to the relevant issues. And because pleadings clarify a number of issues, it can help the parties reach an out-of-court settlement, which is always preferable. The pleading stage is essentially the filing of one document after another. First, the plaintiff will file a writ with a statement of claim attached. The defendant will respond with a notice of appearance saying, "We're going to show up to court." Usually this will include a defense and a counterclaim saying, "This is how we're going to defend the case." The plaintiff may then file a reply to the defense. Both sides may put in what is called a request for further and better particulars, which is just a fancy way of saying, "Hey, can you give us more details?" And finally, each party can then file those further and better particulars. A writ is the most common method of commencing a proceeding in the Supreme Court. It explains to the defendant that an action is going to be taken against them. It informs them where the trial is going to take place and what sort of trial it's going to be. In other words, is it going to be a judge or a jury trial? And it will normally have a statement of claim attached to it. If it doesn't have a statement of claim attached, it will usually, however, have a general statement which gives enough details about the claim for the defendant to know what's going on. Sometimes, instead of filing a writ, the plaintiff can file what is called an originating motion instead. It's the same sort of document, with a few little differences, but what's important for you to know is that it's usually only filed when there is either very little dispute over the facts of the case, or where there is no defendant to be found. So for your purposes, what you need to know is the writ is most commonly used. The originating motion is only used in rare circumstances when there's either no dispute or little dispute, or there's no defendant. In most situations, the statement of claim will be attached to the writ, or the originating motion. The statement of claim simply explains what the claim is going to be, the cause of the claim, and the remedy that the plaintiff wants. Even though they're filed at the same time, it's important for you to know that the statement of claim is different to the writ. The writ provides the basic details like what court it's going to be held in, whereas the statement of claim is about what the case is actually going to be about. It tells the defendant what sorts of claims the plaintiff is making. It will do this by providing facts such as the date when the alleged event occurred and the types of remedy that the plaintiff wants. So it might say, "We're claiming $35,000 because you caused damage to our property." If the defendant wants to actually defend this case, the first document they have to file is called the Notice of Appearance. The purpose of this document is to inform the court and to inform the plaintiff that the defendant is going to show up to court. In Victoria, if the writ was served on the defendant, then the defendant has 10 days from the date of being served to file their Notice of Appearance. If they don't stick to that time limit, the plaintiff has the right to obtain what's called default judgment. You can think of this sort of like the plaintiff winning by default. After the defendant has filed their Notice of Appearance, they then have to prepare their actual defense. They can do this themselves, or they can hire a lawyer to do this. The defense goes through and sets out a response to each of the claims made in the plaintiff's statement of claim. Usually this is in the form of an admission or a denial. So for example, a defense might admit points 1 through 5 of the statement of claim, but deny points 6, 7, and 8, and will then provide a reason why the defendant is defending this case. At this stage, the defendant might also choose to make a counterclaim against the plaintiff. So for example, if this was a contractual dispute and the defendant was being sued, the defendant could make a counterclaim that it was actually the plaintiff who broke the contract or breached the contract. Replying to the defense and counterclaim is an optional step in the pleadings, so the plaintiff doesn't have to do it, but they can choose to file and serve a reply. They might want to do this if they wanted to clarify a particular fact or to agree with the defendant on a particular issue. The defendant can also file a reply to a defense to counterclaim. So in other words, if the plaintiff files a defense to the counterclaim, the defendant can reply to that. Further and better particulars is also an optional step in the pleadings. One or both parties might file a request for further and better particulars if they want more details about the claim or about the defense. The party who gets served with this request must then go and file those further and better particulars, or the court might order it to do so. In class, we're going to be exploring some sample documents from the case of Ansett and Westpac. As with most topics in legal studies, we're going to be looking at evaluating how effective it is. In particular, we're going to evaluate how effective it is at contributing to the elements of our effective legal system. Remember, the three elements of an effective legal system was fairness, timeliness of our legal system, and the ability of people to access our legal system. So you're going to evaluate pleadings in terms of how effective they are at allowing each of these things. The strengths of pleadings is that they allow the parties the opportunity to reach out-of-court settlements without having to go to trial, and this is generally far more preferable. They also provide the parties with the opportunity to determine the strengths and weaknesses of each other's cases. This helps them to decide if they should concede certain facts or issues and therefore speed up the trial. This also helps parties to decide whether it's worthwhile even continuing with the case, and this is another factor that can contribute to reaching earlier out-of-court settlements. Each of these procedures is also intended to provide the court with more information about the case. Because the court receives a copy of each of the documents, it gives it a record of the claims and the defences, which can help the court manage the trial appropriately. For example, by scheduling the right amount of time to hear the case. Some of the weaknesses of pleadings is that they often take quite a long time to complete, since several documents need to be exchanged, and this will add to the delay in reaching a resolution. Or in other words, it might reduce the timeliness of our legal system. Cost can also be a significant weakness here, particularly if lawyers are used to prepare and finalise the documents. They're going to add significantly to the cost. In other words, this weakness could reduce the effectiveness of our legal system by reducing the access people can have by making it too expensive. Access to the legal system could also be reduced by the fact that pleadings are complex and they're difficult to understand, especially for people who are unrepresented. The process also might be abused by certain parties. For example, the defendant might deny a claim even though they have no legitimate defense, which would cause the plaintiff to have to go through the cost, time, and stress of going to court. Alternatively, from the other side, the plaintiff might have a really weak claim, but put in enough detail in their pleadings just to make the defendant spend time and money defending the case. In other words, both sides can use dirty tactics in order to try and cost the other side time and money and make them give up the case. This is particularly harmful when it is used against vulnerable or poor parties and can lead to reduced access to justice. The next civil pretrial procedure is discovery. Discovery is the pre-hearing stage in civil proceedings where the parties exchange further details. It consists usually of the discovery of documents, written interrogatories, and oral examination or medical examinations. The pleading stage is where the parties exchange documents setting out their claim and defense. For example, a statement of claim might say something like, "We claim that the other side has breached their contract." The discovery stage is where all the facts and documents which might prove this case are disclosed. The main stage in discovery is called discovery of documents, and it involves each party disclosing the existence of and then exchanging documents that are relevant to the issues in dispute. Documents could include letters, emails, handwritten notes and contracts, as well as videotapes, audio, discs, films, recordings. It encompasses a wide variety of things. For example, if the plaintiff claims that there is a written contract, then that contract should be something that is exchanged during the discovery process. Interrogatories are pretrial questions, usually written down, sent by one party to another in order for them to ascertain the basis of a dispute. In other words, the parties send each other written questions in order to find out more details. Depending on the answer to the interrogatories, a party might request that the other party answer some questions for them. This is called discovery by oral examination. If the court consents, these questions are then put to the party as if they were being examined in chief, or questioned by their barrister. If the plaintiff is claiming damages for bodily injury, then the defendant might ask the plaintiff to submit to appropriate examination by a medical expert. This is the medical examination stage of discovery. The purpose of a discovery is to require the parties to disclose all relevant material and documents to the other side. This might come as a surprise to you because you might not think that you would want to disclose what your strategies are to the other side. However, the point of this is to reduce the element of surprise at trial and to try and avoid a trial by ambush. This allows each party to determine the strength of the other side's case and determine their own likelihood of success. This might then help the parties decide that they might want to pursue an out-of-court settlement. Discovery also ensures that the parties and the court have all of the relevant documents and material they need to achieve a just outcome. This promotes the goal of a fair hearing for all parties, one of our elements of an effective legal system. In proceedings where the medical state of the plaintiff is in dispute, for example in personal injury claims, discovery gives an opportunity to the defendant to have the plaintiff medically examined. This can reduce the time in court disputing the medical condition of the plaintiff. One of the strengths of the discovery system is that it lets parties understand the strengths and weaknesses of their own case as well as the case of the other side. For example, you might find documents that support your own case, or the other party might discover documents that indicate that their case is particularly weak. And ultimately, finding out this information is more likely to lead to a quicker resolution of a case. Another strength is that it avoids trial by ambush, which ensures that both parties have access to the same documents before they go to trial. The parties are then able to use these documents and the information they found during discovery as the basis for the evidence that they bring during the trial itself. This ensures that the trial is fair and unbiased, or at least as much as possible. The discovery process can also help prevent concerns that the other party is hiding or withholding documents. Because the parties need to sign an affidavit stating that the documents they've discovered are everything they have, this can mean that hiding or destroying documents can have very, very serious consequences. Once again, this helps to ensure that the trial that you receive is as fair and unbiased as possible. Finally, discovery can aid both parties head towards an out-of-court settlement. It allows the parties to assess the documents, see what the information available is, and then make an informed decision about whether they want to go to trial, or whether they want to try something like mediation, or whether they want to settle out of court. Ultimately, this is one of the most important goals of discovery, because the courts try and encourage as many parties as possible to settle as quickly as possible, because otherwise the courts can get clogged up with cases. There are, however, a number of weaknesses to the discovery system. First of all, there's a significant cost involved in doing the discovery process, particularly when the number of documents is quite large. The cost associated with collecting, reviewing, determining whether the documents are relevant or not, preparing affidavits of these documents, inspecting the other side's documents, all of this takes a significant amount not only of time but also money to do. This leads on to the second weakness, which is that it takes a significant amount of time to complete discovery. In fact, with cases with a large amount of documents to be discovered, discovery could take several months or years. This is made worse by the fact that the rules relating to discovery are confusing and complicated. Before you include a document in discovery, you have to determine whether it's relevant, whether or not it's privileged, which means it doesn't have to be included, and whether or not there are rules about confidential or sensitive documents which apply. Finally, some parties can be resistant to discovering all the documents that they should. They might want to hide or withhold documents to try and prevent damaging evidence against them being seen by the other party. This might result in the other party having to seek the intervention of the court and ask the court to force the other party to produce those documents. And again, this adds to the time, cost, and inconvenience of the discovery process. Each of these weaknesses can tend towards increasing the cost and time of the discovery process, which reduces access to justice and prevents the operation of our effective legal system. The next civil pretrial procedure we're going to look at is directions hearing. A directions hearing is a hearing conducted by a judge that allows the courts to establish a timeline for the completion of all the pretrial stages in a civil case. At this hearing, the court will give directions to assist the parties in determining the case as quickly and effectively as possible. A directions hearing is where the court directs the parties to do certain things in order to speed up the completion of the case. The court could direct the parties to file particular pleading documents or other documents such as an expert report by a specific time. or file a particular application, such as an application seeking leave of the court to amend a pleadings document. The court could also choose to direct one of the parties to disclose a particular class of document. This might occur where there's been a dispute between the two parties about the relevance of a certain type of document, and the court could tell one party, you've got to disclose each of these documents by a certain time. The court could direct the parties to attend mediation, or to attend further directions hearings before the matter is set down for trial. The purpose of directions hearings is to set a timetable for the parties to complete future pretrial procedures, such as discovery, or going to mediation, or allocating a date for a trial. The judge gives directions because it allows the matter to progress to a trial quicker. Or in other words, the judge will determine what the next course of action should be. Another important purpose of directions hearings is to determine whether or not it's appropriate for the parties to go to mediation. Parties are often referred to mediation because the court is keen to encourage out-of-court settlement. The more parties are capable of settling out of court quickly, the less trials will clog up the court system. Another purpose of discovery is to hear applications made by the parties. For example, the parties might have applications regarding the sorts of documents they will need to discover, or they might make applications about having time extensions to any of the particular procedures they're going through. One important thing you want to make note of at this stage is that committal hearings and directions hearings are not the same thing. Committal hearings are used in criminal cases to determine whether or not there is enough evidence to go to trial, whereas directions hearings are where the judge in a civil case gives directions to the parties about what to do next. It's worth noting that the Supreme Court now refers all civil matters to mediation and arbitration. They do this to promote out-of-court settlements and reduce the backlog of civil cases that are waiting for trial. This means that during the directions hearing, and at any other stage in the proceedings, the court may, with or without the parties' consent, order them to go to mediation. Or, with the consent of the parties, they could refer the parties to arbitration. If the matter is not resolved with mediation, the matter then proceeds to a pretrial conference, and then it goes to trial. We know that the Supreme Court has a policy of referring all civil matters to mediation and arbitration. What I want you to think about is what impact this might have on access to justice. For example, if everyone is being forced to go to mediation rather than getting their day in court, are they really being able to access justice? Another way of phrasing this question is access to justice the same thing as access to the courts? That's not something we're going to answer now in this PowerPoint, but I want you to think about it between now and the next time I see you in class, and then you can turn your thoughts on this issue into an answer for an evaluate question on this topic. One of the strengths of directions hearings is that they can ensure timely resolution of a dispute by setting a timetable for the different steps each party should take. Directions hearings are also a valuable way of informing the judge and the court about the nature of the dispute and the types of steps that are being taken to solve it. Another strength is that it allows the judge to give directions that the parties attend mediation, which can be seen to encourage out-of-court settlement, which can lower the overall cost of taking a trial through to resolution. It is also the opportunity for both parties to communicate with the judge. This can be useful, for example, if one of the sides or one of the parties is not complying with the pretrial procedures or making things difficult for the other party. So in other words, you can think about this like it's an opportunity for one of the parties to communicate with the umpire and get the umpire or the judge to get things moving properly if the other side isn't cooperating. Some weaknesses of directions hearings are first of all that it's difficult to understand, particularly for people who aren't represented by lawyers. It can also be stressful and inconvenient because usually it does require lawyers to be attending. And finally, it can be a waste of time if the parties are ordered to attend, but they don't have anything to discuss. The last step in thinking about the civil pretrial procedures is to compare them with the criminal pretrial procedures we looked at in our last topic. Remember that the criminal pretrial procedures that we looked at were bail, remand, and committal hearings. Meanwhile, the civil pretrial procedures we looked at were pleadings, then discovery, then directions hearings. The similarities are that both criminal and civil pretrial procedures attempt to make the trial process as efficient and fair as possible. They do this by ensuring that the parties have access to the same information and documents. Both types of procedures also provide the court with information about the case before it begins. This can help to promote a timely resolution of the case, since some issues might be conceded or some charges might be withdrawn before the trial starts, since everyone has more information. Some differences are that in a civil dispute, pretrial procedures are used to clarify issues and let each party know the other's evidence, whereas in a criminal case, pretrial procedures are used to see whether there is sufficient evidence to support a conviction. In a civil dispute, the defendant is required to discover relevant documents. In a criminal case, however, the difference is that the accused person doesn't have any obligation to disclose any documents at all. Another difference is that the accused in a criminal trial might not be able to easily inspect documents or attend directions hearings in a criminal case because they might be remanded in custody. In a civil case, this is unlikely to be an issue.